Hi everybody, my name is Marc Victor. I've been a criminal defense attorney now for well over 20 years, and I've represented thousands of people in major felony cases, as serious as first-degree murder with the death penalty alleged to trial, all the way down to crazy little misdemeanor cases. And along the way, I've represented lots of people in gun cases. I've done state cases, federal cases, appellate court cases, and cases nationally. I've been around the criminal justice system, and I'm here today to talk to you a little bit about guns and things you need to know if you're going to carry a firearm. Okay, so let me get right into the top 5 things that you need to know. Number 1, just shut up. Really, just trust me on this. If you just trust me on number 1, we could move right on to number 2. But some of you are still going to want to talk to the police. So let me fill that in a little bit for you. First off, keep in mind that the police will remind you of my first most important piece of advice. It's called the Miranda Rule. If 2 things are happening at the same time, number 1, you've been arrested, and number 2, you're about to be interrogated, the police are going to remind you of my first most important piece of advice to just shut up. They're going to tell you 4 things. First, you've got a right to remain silent. Second, anything you say will be used against, guess who? You. Third, you have a right to an attorney, just not right now. And then finally, if you can't afford an attorney, one will be given to you for free later on down the line. If you hear that, you should think about what I'm telling you right now. Just shut up. So, also, some of you will actually talk to the police still because you are mistaken about how the law works. In the United States, your statements or your invocation of your right to remain silent cannot be used against you. Some of you might worry about if you go to trial, then a prosecutor might ask the police officer, hey officer, what happened? And then the officer is going to say, well, I asked him to explain to me what happened, and he said, I'm just going to shut up, or I'm going to invoke my right to remain silent, or even better, I want my attorney. And then that'll be used against you, and the prosecutor will argue to your jury, hey, ladies and gentlemen of the jury, if this defendant really was innocent, why did he just shut up? I'm here to tell you that's not going to happen. In the United States, in all 50 states, our Supreme Court has ruled that your invocation of your right to remain silent can't be used against you. So what is actually going to happen if you go to trial is the prosecutor and the police officer are going to skip right over that. They're not even going to mention to the jury that you invoked your right to remain silent. And if they do, your defense attorney will likely make a motion for a mistrial, and the case will be dismissed, maybe with or without prejudice. So don't worry about invoking your right to remain silent. It's also not going to be a reason to have you arrested. Other reasons to just shut up. Well, if you open your mouth, you are limiting legal theories. You might not be remembering things correctly, especially after a shooting. You're stressed, you're under a lot of pressure. It's really a horrible time to be recounting little tiny details about what just happened. If you get something wrong, or if something is misunderstood by the police officer who might be hastily writing things down, that could be used against you down the road. Imagine a police officer asking you, where did the bad guy enter your home? And you say, over there. You might be pointing to the window, but the officer might think you're pointing to the door. The officer may write down that you said he came in the door. Later on, when your case goes to trial and you say, no, I said he came in the window, and the police officer says, no, he told me he came in the door, you've got a problem now at trial. So worry about mistakes that a police officer might make in writing down exactly what you said. Plus, you might say, hey, I shot this person because I was in fear for my life, and maybe it turns out really what you were doing was shooting this person because you were in fear for another person's life. Yeah, you have a right to protect a third party against another person's unlawful use of deadly physical force, and so you can use deadly physical force to protect that person. But if you said, I was in fear for my life, that theory's out the window. You're going to be stuck with that. So you might have said something you didn't mean. Maybe you didn't think it through carefully. the best policy really is to just shut up. Also, keep in mind, although most police officers are good police officers and they're honest and they do a very good job, some aren't. Like everyone else, there are bad police officers, some of whom might not like the idea that you have a firearm. So are you really going to trust 10 or 20 or more years of your life and your liberty to some police officer who you have never met, who you don't know anything about their attitudes in regards to you having a firearm? Don't do that. Just keep your mouth shut. Trust me on this one. Now that I've told you to just shut up, few exceptions to the just shut up rule. First off, if you've been involved in a shooting, I recommend that somebody call 911. Look, it's not going to play very good at your trial if you call your lawyer before you call 911. The best policy is get a buddy of yours to call 911. Really short and sweet. Hello, 911. There's been a shooting. Please send help. Here's the address. Bye. If you can't get a friend to do that, then I recommend you do it. Call 911. Just say, hello, 911. There's been a shooting. Here's the address. Please send help. Bye. And then hang up the phone. And then be prepared for the police to come. So don't get shot. Make sure your gun is securely put away and put your hands up just so there's no misunderstandings. Do not present anything that could be construed as a threat to the police. Another exception to the just shut up rule is traffic stops. Look, if you want to try to talk yourself out of a crazy little speeding ticket, have fun. I don't necessarily recommend it. If you're speeding and you get pulled over, take your lumps and move on. But if you want to try out your charm on a police officer and try to talk your way out of a ticket, go right ahead. Incidentally, I've found in representing people for over 20 years now, the best policy in trying to get out of a ticket, just own up to it. Say, look, officer, I'm sorry. I was speeding. You got me. I feel bad about it. Maybe they'll give you a warning. If not, just pay it and move on. Third exception, after consultation with an attorney. There may be times, even after a shooting, where you've come in and you've discussed the matter with an attorney and the attorney has made a decision that you should make a statement. It might be in your interest to make a statement, but that's a decision you got to make after you've consulted with an attorney. Don't do that at the scene. Let's get all the evidence. Let's take a look at everything. Let's let you settle down. Let's go through everything carefully and then determine if it's time to make a statement or not. Don't believe the police officer that this is your only chance to make a statement. It's not. You can make a statement anytime you want. Okay, those are my 3 exceptions. Other than that, trust me on this one, folks, just shut up. Okay, moving along to number 2. And this is one that I think is very important for people to understand. And I put this one in here as a result of me giving many talks over 20 years to lots of gun groups. I speak at the Crossroads Gun Show on a regular basis. I talk to lots of people about firearms and shooting. And you guys love to give me questions, hypotheticals. They usually go like this. Hey, Mark, if I'm in my house and it's 2 o'clock in the morning and I hear a thud and I look up and there's a person and then this happens, and then I shoot him, am I okay? Or something along those lines. What I want you to understand is how I hear that question and how all lawyers hear that question. We hear that question like, hey, Mark, I would like you to predict for me how either 8 or 12 people on my jury will determine, after hearing all the facts and circumstances, the answer to the question about whether what I did was reasonable. That's it, ladies and gentlemen. That's what it really comes down to. The question is one of reasonableness. That's what self-defense is going to come down to. Considering all the facts and circumstances of what happened, who you are, what's your size, what's your weight, what weapon you had, what you believed about the bad guy, what weapon you believed they had, what was going on, what was the distance, what was the risk. Considering all of that and considering what you did, was it reasonable? If it was reasonable, you get to walk right out of the courtroom and buy your attorney dinner for doing a good job at your trial. If it wasn't reasonable, you get a new set of bracelets and you get carted off to the jail. That's really the question that the jury is asked to answer in a self-defense case. I don't know about you, but a lot of people have different opinions about what's reasonable. I don't want to trust my freedom to what other people might think is reasonable. Therefore, I'm very conservative in terms of pulling out a firearm, and I strongly urge you to be equally conservative. Now, there are some predetermined rules that our society, that our state, have determined already are reasonable or unreasonable. Let me just give you a few so you'll know. If you want to use physical force or deadly physical force in claim self-defense, the threat that you are responding to better be imminent. Said another way, if the threat's not imminent, your use of physical force isn't reasonable. What do I mean by that? If somebody threatens you, if somebody makes a threat to use physical force against you, unlawful physical force, and they say, I'm going to punch you in the face tomorrow, you don't get to use self-defense today. It's not imminent. It's got to be right now. Another example of a rule that's already been determined about reasonableness is mere words. If you're intending to use physical force in claim self-defense, if you are using that in response to mere words alone, I'm already going to tell you it's unreasonable. We've decided as a legal matter, physical force in response to mere words alone is unreasonable. Don't do it, no matter how offensive what it is somebody said is. I don't care if they've made fun of your spouse, your favorite sports team, your religion, the flag, the Bible, whatever. No matter how offensive it is, people have a right to free speech, and you never get to use physical force or deadly physical force in response to words alone. That's unreasonable. Already been decided. One other one, I'll give you an example. You don't get to use deadly physical force to protect property. I don't care that somebody is planning to steal your big 90-inch screen TV. You don't get to use deadly physical force. We have already decided here in Arizona that the use of deadly physical force to protect mere property is already unreasonable. Don't do it. That's what I want you to understand. You don't have any idea who's going to be on your jury, and you don't really know what they might determine to be reasonable or unreasonable. Therefore, if you can avoid the situation, you ought to. And keep in mind, juries vary by community. You might get one jury in Yavapai County, completely different jury in Pinal County with completely different attitudes. And different communities have different attitudes about guns. I also want to let you know I've picked many juries and asked them lots of questions about guns as we're picking the juries. I usually ask them, raise your hand if you think that our gun laws are too strict. Raise your hand if you think they're not strict enough. And I want you to know, in my experience, there are more people in our state, our gun-friendly state of Arizona, who think that the gun laws are not strict enough. Keep that in mind when you think about pulling out a firearm. Number three, the third most important thing that you need to know. Us lawyers, we don't argue about the law for the most part. We understand the law. When I call up a prosecutor, we're not arguing about the law. There may be a situation where I quote something and they say, well, I don't know if I agree with the law. We look it up, we figure it out pretty fast. We don't argue about the law. What we argue about are the facts. That's what I want you to understand. The way these go in these gun cases is my client comes in and explains what happens, and they may have a very good argument about why they used self-defense. And I get on the phone or I meet with the prosecutor and I say, look, man, let me tell you what happened. My client did this and this and this and this, and you're prosecuting him. He's a good guy. Why don't you drop the case? And the prosecutor inevitably will say back to me, hey, Mark, those aren't the facts that I have. Guess what? It shouldn't surprise you that the victim in a criminal case always has a different version of events, right? You might say you just put your hand on your firearm. Don't be surprised if the victim and all of the victim's friends say something more like, you pulled out your firearm and pointed it right at them. We argue about the facts, not the law. There will be lots of different versions of events. People see things differently. People also lie about things. So it's not necessarily about what happened. It's about what people will say happened. And you need to be aware of that when you think about pulling out a firearm. What is the evidence? What do the witnesses say? And how many witnesses are there? By the way, guess who's going to be the most biased person in the courtroom? You, the defendant. I'm already going to tell you that prosecutor is going to argue to the jury that you are the defendant. You have the most to win or lose here. Obviously, your version of events is biased. Guess who's going to be believed? The police officer with the shiny badge. Or the poor victim who says, oh, I was so scared about the gun being pulled. Now, I don't know what happens in these cases because I'm not there. I'm just telling you sort of a distillation of 20 plus years doing criminal defense. We're going to be arguing about the facts. That's what juries do. They figure out what the facts are. So don't be in front of a jury. Don't trust your freedom to arguing over the facts. Be very conservative about pulling out a firearm. Number 4, you need to understand something if we're going to talk about gun cases. Mandatory minimum sentences. It's the reason why your gun case probably isn't going to trial. You're probably never going to get that far. Why do I say that? I love to try cases. I wish I could try more cases. Let me tell you why your case probably isn't going to trial. First off, about 97-98% of all cases don't go to trial. They end in plea bargains. And the reason they end in plea bargains is because the prosecutor understands mandatory minimum sentences. You need to understand them. I want you to understand them now before you need to understand them after you're charged. Almost all gun crimes in Arizona will carry with them a mandatory prison sentence. Yeah. If the jury finds that what you did was unreasonable, you are going to prison. And it doesn't matter that you have no prior criminal offenses. It doesn't matter that you're a good person and you have kids and you're going to lose your job and a bunch of horrible things are going to happen in your life. The judge isn't going to have discretion to put you on probation. In my opinion, this is done intentionally. This forces people to take pleas, right? Imagine a case where you've engaged in a shooting in your home, and maybe the person dies, and you come in and you explain the situation to me, and I say, yeah, it looks to me a pretty good shooting. And I would never give you a 90% chance of winning at trial. The best any competent criminal defense lawyer is going to give is probably 50%. But imagine I still told you 90% chance you're going to win at trial. What does that really mean? It means a 10% chance you're going to lose. And that's a 10% chance you're going to go to prison for maybe 20 or more years. If the prosecutor comes up and says, hey, I'm going to offer you a nice plea, you're going to get probation, maybe a 100% chance of probation. I'm going to tell you already, you're not going to take a 10% chance of spending 20 or more years in prison when you have a 100% guarantee to probation. And that's how it works, folks. The prosecutor is going to offer you a deal that's too good to refuse. And most people aren't going to want to roll the dice on a mandatory minimum sentence. Now, I would love it if the law changed. And I think the law ought to change. I wish we could get a change that said, notwithstanding any law to the contrary, the judge always has the right to put a convicted criminal defendant on probation. If we could get that, we could try a lot more cases. Probably we wouldn't, because ultimately the market in plea bargaining, the prosecutors, would just give us better pleas and be a little bit more reasonable in these cases that were better for us. But right now, they know how it works. And they say, look, Mark, I understand you got some arguments here, and I understand there's some chance you could win at trial, but the truth is, your guy's not going to risk it. And they're right. You're probably not. Keep that in mind when you're thinking about pulling out a firearm. You probably are never going to make it to trial because the risk is too high. Also, keep another thing in mind just before I leave this point. I don't get to tell the jury about the punishment. I wish I could tell the jury about the punishment. I wish I could tell the jury about jury nullification. But I can't say anything about that because jurors in Arizona are sworn to follow the law, and defense attorneys are not allowed to tell the jury what the punishment is. So a jury might convict a defendant thinking that, well, it's not that bad of a case, it was a pretty close call, I'm sure the judge will give the defendant probation. Not going to happen. In a gun case, like I've said, almost all of them, they're mandatory prison cases, and the jury doesn't get to know about that. Keep that in mind. Your jury will be ignorant about the fact that your gun case is a mandatory minimum sentence attached to it. Okay, number 5. This is really the most important thing you need to know. Number 5 is what I've come up with, sort of the Marc Victor analysis in terms of what I want you to think about in those few seconds that you got when you're thinking about pulling out your firearm. Now, the ideal situation, right, is you've got your firearm and you're out at a restaurant or something and this situation is sort of brewing and you're thinking about it. I would love it if you'd just give me a call. Call me up and say, hey, Mark, and by the way, I'm available 24/7, 365. I'm very easy to get a hold of. You can call my law firm anytime. You can reach me on the web at Attorney for Freedom. And I'll take your call, even without any money in my trust account. I'm happy to talk to you. You might say, hey, Mark, I'm thinking about pulling out my firearm. Can I do it? What do you think? And I'll say, fantastic. Tell me what's going on. Where are you? What's the threat? How far are they? What's your weapon? What weapons do they have? Who's around? What's the situation? And after about an hour of consultation, I'll be able to give you a very conservative opinion about whether or not you can pull out your firearm. What's the problem with that? You already know the problem with that. If you got that kind of time to think about whether to pull out your firearm, I can already tell you, don't do it. Why? Because it's not imminent, right? So it's going to be unreasonable. If you got more than just a few seconds really to think about this, you probably shouldn't be pulling out your firearm. So we got to come up with something that you can do in just a few seconds. I think I've come up with something to help guide you in this area. It's called being prosecuted. This is what I want you to have in your head when you think about whether you should pull out that firearm or not. I want you to think about, I'm going to be prosecuted. Let me break that down a little bit for you. Here's how prosecuted goes. After you pull out that firearm, the boys in blue are coming, and they're not going to be very friendly towards you. They're going to escort you to the ground. If you've ever been escorted to the ground before, I can imagine it's not a lot of fun. You're then going to be given a new pair of bracelets called handcuffs, and you are going to be cuffed and stuffed in the back of the police car, driven down to the jail. Not to fret, you're going to get a hearing in front of a judge to determine release conditions within 24 hours. But it's not going to be the kind of hearing you're expecting. That judge is already going to have reviewed a Form 4, which is going to lay out the facts and circumstances from the officer's point of view, the same officer who decided to cuff and stuff you. The judge is probably going to set a bond much higher than you expected, and it may be cash only. It might be difficult for you to bond yourself out of jail. Imagine you're going to be charged with the crime of aggravated assault, which is a 5 to 15-year mandatory prison sentence for a first-time offender. If you do get out of custody, it's probably going to not be really fun for you for the next maybe at least 6 months to a year. You're going to think about this every day. You're going to be stressed every day. You're going to have problems eating. Things that used to be fun just aren't going to be fun. You're going to call me every day and say, hey, Mark, anything new on my case? Anything new on my case? And I'm going to tell you the very unsatisfying answer, we're still working on it. And you're going to go through a miserable year. And I'm going to remind you about mandatory minimum sentences. And at some point, the prosecutor might make a plea that you're not going to love very much. And you might decide you want to accept that plea, which might be for probation, instead of taking the risk of going to prison. And you might have to go to court and plead guilty, and you don't really feel very good about it. And you might be left being a prohibited possessor and maybe being a felon for the rest of your life. Let's call that being prosecuted, as I've said. That ain't fun. So keeping that in mind, back to our couple of moments to think about whether you're pulling out your firearm or not, here's what I want you to do. If being prosecuted is worse than whatever is going to happen right now, then don't pull out your firearm. On the other hand, if what is about to happen is worse than being prosecuted, go ahead and pull out your firearm. Now, let me give you some examples of what I mean by that. If you don't pull out your firearm right now, you're going to be dead. Let's see, being dead or being prosecuted? I think I'd rather be prosecuted, so pull out the firearm. Another example, if you don't pull out your firearm right now, somebody you love, or at least like a lot, is going to be dead. Well, let's see, being prosecuted or somebody I love or at least like a lot is going to be dead. I think I'll take prosecuted. Pull out the firearm. Let me give you an example from right here in this office. I had a client who came in and he pulled out his firearm and he got charged with aggravated assault, 5 to 15 years. And I asked him why he pulled out his firearm. And he told me he was about to be disrespected. So let's run that through the Marc Victor analysis. Disrespected or prosecuted? I'll go with disrespected, right? Disrespect me all day long before prosecuted. Don't pull out the firearm. Hopefully I've given you a little bit of a feel of just how serious I want things to be before you pull out your firearm. I want you to really think for a moment about being prosecuted, how big of a deal that is, how long, how life-changing that can be. It could be a long, stressful, expensive, miserable time that doesn't even end very well for you. That's a serious deal. I want it to be more serious than that for you when you pull out your firearm. You really got to be very conservative. You don't just pull out your firearm because you're being disrespected or somebody's bothering you in some way or either somebody's even smacking you in the face. Just get out of the situation. Pulling out a firearm can be a life-changing type of a thing, and I recommend that you be very, very conservative when you do that. Okay, so those are the 5 most important things that you need to know. It's far from everything you need to know. We haven't covered a lot about self-defense, but those are 5 things that I've sort of distilled down from my 20-plus years doing criminal defense cases that really you can't get from reading the statutes. You really can't get unless you're in the trenches of doing criminal defense cases like I've been for over 20 years. I hope I've conveyed the point that you should be very, very conservative in terms of pulling out a firearm. Look, there may be a time where you need to pull out a firearm because it's absolutely imminent to protect your life or the life of a third party. I get it. Those are the decisions you're just going to have to make. Don't do it if it's less serious than that. Be smart. If you can get out of the situation by using your brain or talking your way out of the situation, do that and live to enjoy another day. Who cares what people think? It doesn't matter that you have a legal right to stand your ground and you don't have to retreat. My personal advice to you is be smart and avoid situations that you might get into that would require you to pull out a firearm if you can. There may not always be those situations, but be smart. You really have an obligation to be informed and to be a responsible gun owner. Don't be a statistic of one of these crazy gun owners who makes us all look bad. Learn about the law. I'm happy to help you and guide you through. There are lots more things to talk about. You have the Arizona statutes that you can go through. There are a lot of books that can help you, but if you have questions, specific questions that you want to address to me, that's fine. I'm an easy guy to reach. You can always get a hold of me. Just shoot me an email at marc, M-A-R-C, at attorneyforfreedom.com. All spelled out, attorney, F-O-R, freedom.com. I'm standing by to help you. Thanks for your attention.